Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark from the Clark Law Firm. We are located at 1563 Main Street in Peckville, and at my office I focus on landowner representation and only landowner representation. I am here with you every Sunday on these stations from 8 to 9 a.m. to provide landowners valuable information that you need regarding the natural gas development here in Pennsylvania. A little more of what I do. Again, my focus is entirely on landowner representation. Only landowners, not the gas companies, not the pipeline companies, none of the companies, just the landowner. I have and continue to represent people for gas leases. I've done hundreds of gas lease negotiations all across the state. Pipeline agreements, water line agreements. We're up to about, I think I've done agreements now with about 50 companies across the state of Pennsylvania. So we do many pipeline agreements. And just a quick jump in that if you do have or you are approached with a pipeline agreement, please go speak with somebody, get some assistance, and whatever you do, in my opinion, whatever you do, do not agree to anything. Don't agree to price. Don't agree to anything until you talk to an attorney or an attorney that can assist you. Whether it's me or somebody else, please make sure you talk to somebody. These pipeline agreements are following the path in a lot of cases like the leases. Now, what I mean by that is you're going to see pipeline original offers were very low and they've increased over time. And in some cases, they've increased to $50, $60, $100 or more per foot. It depends on your situation. A lot of people are not taking advantage or protecting themselves with these agreements, and you got to make sure that you understand your situation. I see some people with these pipeline agreements that we're representing getting compensation that I never, ever even dreamed of being possible a few years ago. But now we've learned and we've seen that, hey, if you're in that right situation, you can really take advantage of this opportunity, and many times get literally six-figure pipeline deals and high six figures in some cases, depending upon your circumstance, depending upon the length and how much is involved, but most importantly, depending upon the need the company has to get across your property. I've seen people with pipeline easements of just 100 or a few hundred feet get thousands upon thousands and thousands of dollars because the company needed to use that property and couldn't get around them. So it's so important, and I'm jumping my script as I often do, but if you have a pipeline agreement, do not agree to anything. All the time, what happens so many times, I get a call from a landowner, they become a client, and the company says, well, your client agreed to blank dollars per foot, or they agreed to so many dollars per disturbed acre. And my response has to be, when I look at this, well, maybe they agreed to that because they thought that's all they could get based upon what you told them as the company representative. You as the company representative, you're not going to tell them how much the company is willing to pay for this pipeline easement or any other agreement that's being offered. You as the pipeline or gas company representative, it's just your job is to try to get the best possible deal for your client or your employer, not the landowner. It makes perfect sense. So please, landowners, know this. Always know this, because we're seeing it. There are so many opportunities. There are different types of opportunities. I said, I've done hundreds of gas leases. Well, now we're working on so many of these other contracts. I still have gas leases from places all across the state. But we have these other contracts now that also provide very nice opportunities for a landowner to get some additional compensation. But I say it's not all about compensation. We always want to maximize compensation, but it's also about how long is the company going to be there and what other terms do you have, and eliminating surprise. So we're finding the percentage of times when I'm called and we get involved and I get involved, the results, and we're very proud of this, but we have opportunities all the time, almost every single case. And in fact, I mean, literally almost every case, we're able to strengthen agreements, sometimes considerably. And as far as compensation goes, I'm usually able to tell within the first couple calls, couple exchanges with the company, whether or not there's any flexibility here in the compensation. So please, whether it's me or somebody else, if you have any of these agreements, you need to contact an attorney who understands, who knows the market, who can help you out. My quick commercial part, if you want to call me, you can call me anytime at 570-307-0702. That's 570-307-0702. You know, I get frustrated from just my perspective where I see when landowners call, I see what they're being offered, and then we end up representing them, and maybe they get 10 times more, 20 times more, and it's not all the time, sometimes 50 or 100 times more in some rare cases, but I know how many other people just are believing what they're being told and simply sign what's placed in front of them. It's not what you should be doing. And what we say, when I say all the time, is somebody contacts me and I know that I can help them, then we're going to explain to you, hey, look, think we can help you. And sometimes, hey, I'm very confident we can help you. You know, there's never a guarantee. Nobody can do that. But we can say, well, look, the last 20 people in your circumstance, we've been able to help significantly, and we think we can do that for you as well. You have to understand this market. You have to be taking advantage of these opportunities. And also, you have to be in a situation where you're not being taken advantage of. You need to become educated. You need to become informed so the companies aren't taking advantage of you, because it's occurring all the time. People are falling for the same kind of tricks that these companies have been using for a long time. Now, I've been talking this way for a while, for the last few shows, kind of focusing on this because it happens every single week. Every week. I get a call from new clients and they send me the documents and I look at this and I say, oh my heavens, thank heavens you called me, because this offer is atrocious. And here's the reasons why. And I have one I'm going to talk about today. This is a prime example. If you listen to today's show and you think, well, you know what? I'm just going to go ahead and sign, or I believe these company guys, or they're working for me. You know, he's a nice guy. He's trying to do what he can for me. Stay tuned today, because I'm going to talk a true, 100% true. Got the documents right here in front of me. I'm going to tell you this story and just show you how these companies operate. And ultimately, this particular client will most likely, if he decides to move forward, he's going to get at least 20 times more compensation than what the guy offered him, the landman offered him when he went to visit him. At least, and possibly much higher, or he may just say, hey, I'm not going to sign. So this is a great example. And thankfully, the client came to me because he was scared, he was confused, he didn't understand. And so it just takes a conversation. Now it's like the big light bulb goes on and says, oh my heavens, thank gosh I came and got some more information, because I didn't even know any of these things and I didn't realize my options. So I'm going to talk a lot about that today, a true story occurring in northeastern Pennsylvania. And if this example, and I tell you this too, this is a small example. I got many other examples and more severe examples, but this is one that just occurred this past week. Great example here. So I'm going to talk about this. It's a roadway agreement. It's an agreement that the landowner was presented by a gas company representative, a landman, and had some pipeline work also, called us up, came in, sat down, had a conference, explained everything, and now I'm going to explain this to you and what we're looking at and why, just this one example, why you need to be careful. I am Attorney Doug Clark. This is All Things Marcellus. We're here every Sunday from 8 to 9 a.m. to give you good information. Again, general information, things you should be thinking about. I say all the time, I said last week, I said the last several weeks, that we're going to talk about a roadway. I'm going to talk about a roadway agreement today, but the same exact thing holds true for pipeline agreements. This same principle and any other agreements like storage agreements, sometimes well site agreements. This is one example, but if you're saying, well, I don't have a roadway agreement in front of me, or I don't think I'm going to have that, that's fine. Check this out, because the same principles apply if you're presented with a pipeline agreement. All right, back to my script just real quick. Again, who am I? Representing landowners. I'm doing a lot more estate planning work with clients as people are starting to transition into royalties. We want to make sure that you have a proper plan in place for you. Of course, my royalty work, if you're getting royalties and you have deductions taken and you're not sure whether the company should be taking deductions, you can send me your lease and your royalty statements and I'll do a free confidential evaluation and give you my personal opinion whether the company is breaching your contract or your gas lease by taking deductions. You can do that. Call us anytime. 570-307-0702. I currently represent approximately 160 clients in litigation, in claims against Chesapeake, claims against Chesapeake for improper royalty deductions for such items as gathering and transportation. So we're very active in this litigation. We've also, I've approached other companies and several companies in the past based upon our position and our legal position and our arguments have changed their position and have now stopped taking deductions for particular clients of ours. So you need to check this out. It's free. It's confidential. There's no obligation. It's not a gimmick. I want to make sure that you understand where you are and is the company taking, in my opinion, improper royalty deductions. Then you can go get 20 other opinions if you like. I really do. I want to make sure that people aren't being taken advantage of the best that I can. To make sure that whether you ever call me, that maybe people are thinking about these things. And so when you get a roadway agreement or you get a pipeline agreement and you don't call me, maybe you call somebody else, but you don't just sign this agreement. Too many people are being taken advantage of. And like I say, I don't know if frustration is the word, but I know that so many times that I see maybe it's the third or fourth agreement that a landowner has, and they'll give me a call and they come into the office and they bring in these other agreements. And I see that they signed their gas lease at a time where a lot of other terms were available or more money or percentage may be available or may have been available, but they were afraid or they didn't contact me or another attorney and they signed a bad gas lease. Then they signed a pipeline agreement where I know exactly the type of terms I was getting with all these different companies at different times throughout this process. So I'll see a pipeline agreement signed in 2011, 12, 13, whenever, even 14, and I say, wow, man, we don't want to beat it up, but boy, I wish you would have called me because we could have put so many limitations here, or we could have got you additional money for this other work. Sometimes, double the money. So please make sure, whether it's me or somebody else, get some assistance. You can contact me anytime at 570-307-0702. And like I said, we're here every Sunday, where I am here. I always say we. It's just me. I'm here every Sunday from 8 to 9 a.m. on these stations. And what we do is we archive the radio shows on our websites at pagasleaseattorney.com and pipelineattorney.com. I've been doing the show since August of 2010. So we're coming up on our fourth year of doing the show. I say this every once in a while. When I first started doing it, I never did any radio. I never ever was on the radio ever. But what happened was I was approached, and my wife kind of gave me the little nudge and said, go ahead and do this. And I thought, oh my gosh, what am I going to talk about in this first show? I have no idea what the heck I'm doing. And then thinking, how am I going to do a second show? Now, here we are. We have 150 plus hours available. Prior shows available up on the websites. You can go to pagasleaseattorney.com or pipelineattorney.com. Again, that's pagasleaseattorney.com. Go check out the websites. You can get access to all the prior shows. We archive them up there. We index them. So if you're interested in gas leasing, the royalty actions, the improper deduction claims, check those shows out. They're all available on the websites. You can also, we're now on YouTube. You can check us out there. You type in All Things Marcellus on YouTube, my name if you want. Search YouTube, you can find. And then once you find the shows, you'll find a bunch of them up there. And what we do, we want to make sure that everybody has free access anytime to the shows. So we're on, again, YouTube, the website, pagasleaseattorney.com. We're also on iTunes. Type in All Things Marcellus in the podcast section. You can check us out there as well. And again, 150 plus, we may be at 160 plus hours of radio show at this point. So make sure you check out that as well. And even if you're just visiting the websites for a lot of great landowner information, go to pagasleaseattorney.com and pipelineattorney.com. Okay, when I get back, I'm going to talk about this true real-life example, and I believe that this is an outstanding illustration for you as a landowner, that if you're communicating with the landman right now, or if perhaps you're contacted in the future, you want to stay tuned, you want to understand this, and you want to see, hey, this is how they operate, and this is what I need to do to defend myself. And I'm going to tell that story. I think it's very interesting. Stay tuned. I'll be right back after this quick break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And again, I am here every Sunday from 8 to 9 a.m. these stations to give you good quality landowner information. And I'm kind of excited about today. And why I say that is, when I do the shows, things come up during the week, and I kind of take little notes, or I even shoot myself emails as a reminder, hey, this is a good thing maybe to talk about in the show. And I'm always looking for an item that not only applies to people with this specific agreement, and in this case I'm talking about a road right-of-way and easement agreement, but also what also can go beyond that. In other words, well, not everybody's facing a roadway agreement or has an offer or request for a roadway easement agreement. However, a lot of people have pipeline easement agreements that they're being presented with or will be presented with, and storage agreements or other agreements like that, or even well site agreements. So we say, okay, well, where can I find one example that we can broaden and say, okay, how it applies to other people as well? And this is an outstanding example. And also, not only that, but in this particular case, what we also have is we have an outstanding example of how important a gas lease is and the basics of the gas lease and how it's the foundation of these future agreements. And as we go forward, we're transitioning into a time where people were starting to see some more development in the northeastern part of the state. A lot of the companies now are starting to develop under some of these leases that are more landowner friendly. They were producing and developing under the initial leases that were very company friendly. In other words, they targeted the big landowners early on for low compensation, 12.5% royalty, deductions, all of those things. So if that wasn't, kind of bad enough for you in that circumstance, if you signed one of those early leases, and many people obviously did, and it's certainly understandable. But what happened then is well, now comes development time. So the company says, hey, we're going to put a well site on your property, and maybe they're not going to pay very much in any types of damages. You're not going to have a lot of input on where the well site is going to be. Maybe you have no input at all. So they're developing under these leases where the landowner has very little or even no control whatsoever on how these surface operations are going to occur. So these leases evolved, after starting in 2007, mostly in 2008, we start seeing landowners negotiating much better terms in their oil and gas lease. Well, why did you do that? Well, we negotiated better terms to get more money because the market was going to be able to produce more money and better financial terms and higher royalty percentages. But also, landowners negotiated for terms as far as how the company was going to operate on their property, to restrict the ability to company to just come in and do anything they wanted anywhere on the property, to negotiate where maybe a well site location could be, where pipelines could be, where a roadway could be. Also to negotiate how much compensation you would receive if there was going to be activity on the property. In many cases, negotiating how wide or how big a future easement could be, how big a well site could be perhaps, how wide a roadway could be. Also, Can you just come in here and put pipelines all across the property or roadways? Do they have to go to my wells, or can they go to any other property? So people started to become a little more savvy and started to negotiate, and their attorneys and people, whoever it was, started to negotiate more restrictions to their benefit, to the landowner benefit. So what we have every single day, we have landowners who have some of these older leases that don't have any of these negotiated addendum terms, and the company comes in and says, we're going to put a well site, or we're going to put a roadway, or we're going to put pipelines, or we're going to use this area for a tank farm or storage, and that landowner is upset. And Atlanta says, well, I don't want to hear it. I don't want it there. Or, this isn't enough money to justify that. This is my field that I harvest every year, and now I'm not going to be able to do that. I can't plant it anymore because of this activity. And even after the activity, I'm not going to get the same type of yield for a while because the soil is going to be messed up. And so you're sitting there and you got this problem of, boy, this really stinks. I want to try to have some more input, maybe combat it, put some restrictions on this. And what the company will tell you, I promise you, what they're going to tell you if they don't want to do something, they're going to say, well, your lease allows us to do this. Your lease allows us to do this. Again, your lease allows us to do this, what we want to do. The company will say that every single time if they want to do something and they have the ability in the lease. Why again? Why did landowners negotiate restrictions on future pipelines, roadways, and well sites? Because that's what you wanted. That's what is simple. You wanted to make sure that companies couldn't come in and do whatever they wanted on your property without you either having a say or you getting a guaranteed compensation, or to make sure that, hey, if there was going to be a right-of-way, it couldn't be more, say, than 40 feet as opposed to 100 feet that the company may want or say is reasonable if you don't have those restrictions. So in a lot of cases, the restrictions that were placed in leases in combination with the money received, that was the motivator for that individual landowner to actually sign that lease. Many people had various options in front of them. Different companies were trying to lease their parcel, and they took the lease, in maybe the financial terms were identical, but they elected to go with one company over another because they liked the terms of their lease, that lease that this particular company was offering better than the other. And it may have been because of these restrictions on how surface activity could occur, how much input they would have as the landowner, how reclamation or repairing or reclaiming that property was going to occur. That was an important factor, and many times that was the deciding factor. You may also, many people joined groups. For example, the Wyoming County Landowner Group, there's an Auburn group, there's many, I'm not going to say them all, but we have the Friendsville group, there's many other, the TAG group, there's many other groups out there. And some of them are smaller groups that don't have these big names and thousands of members, but you worked hard to get these better terms. So now companies come knocking at the door and they want to do things like put a well site on your property. They want to maybe put pipelines or a roadway. And you need to. The first thing you need to do is, first, don't agree to anything. Second, we got to pull out your lease. We got to pull out your lease, and we have to see what do you have in the lease and what kind of input do you have in what they're suggesting. Do you have the ability to say no? Hey, I don't want this roadway. I don't want this pipeline. I don't want this well site. If you do say no, then we have to assess, well, what does that mean? And in most cases, it doesn't hurt you in any way in the world, in the vast, vast majority of cases. So we want to make sure that we're looking at all of those issues, but we're going to break out that gas lease, because if the company wants to just merely put some sort of, make it simple, put a roadway across your property, and they don't have the ability to do this under the roadway, or under your gas lease, they don't have the ability, then you can simply say no. And again, if they had the ability under the lease and they wanted to do it, the company would do it. So when you negotiate and you fight, or you join this group and you go and you choose this lease form, this particular agreement, the company agreed to it, you agreed to it. The company expects and demands and rightfully so, I have to say, that you follow the terms of the gas lease, and they demand it whenever those terms are in their favor. When the gas lease allows them to do the activity that they want to do, or they're asking to do, or they're asking you to sign an agreement, they're going to point to that gas lease and say, well, we have the power under the gas lease. Please, landowners, please understand that when a company does not have the authority under the gas lease, you do not need to simply sign some sort of bad agreement. Or a lot of times a company may have the authority to, and I'm going to talk about it here in a moment, to put a roadway on the property. However, maybe your lease has some substantial limitations on that roadway. Maybe the roadway language in your lease is very beneficial to you. And what you're going to find is, across the board, in my experience, that the company is going to come to you with a road easement or some sort of similar document, and that a document for that roadway is going to provide you a lot less as far as protection typically than what your gas lease already did, and it's going to expand typically greatly the power that the company would have had under the gas lease versus you signing this new document. And I'm going to explain this all here now. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m. Prior radio shows are archived on the websites at pagasleaseattorney.com. And again, you can contact me by telephone at 570-307-0702. Okay, let's talk road right-of-way and easement agreement. So client landowner calls me, says, hey, I'm presented with a road right-of-way and easement agreement here in northeastern Pennsylvania. So I say, okay, will you go ahead and provide me? I'm pretty sure I'm going to be able to assist you. We get a little intake and we get some history. So please go ahead and provide me all relevant documentation, including, not limited to, there's a little legal lingo there, including but not limited to, the road right-of-way and easement agreement, as well as your lease, and then any other pipeline agreements or whatever else we have going on out there. So this was a great case. I love these cases because what I'll tell the client too, look, we get in and out. If you say you don't want to do it and you have the ability to say no, then we're going to talk about, is there an amount of money that's going to make this work for you? If there is, let's put that money out there to the company. If there's also, we want to make sure there's a location. If there's a location and the amount of money that'll make this work, let's put that out there first and say, hey, company, instead of $20,000, it's going to be $50,000 or even $100,000. Whatever that number is for you as an individual, we put that out there and we say, if you can do the roadway or pipeline at this location and you're willing to pay this certain compensation, then let's go ahead and bang out these terms. But if you're not willing, company, to pay the compensation that I will require to justify this activity on my property, and if you're not willing to locate the road or a pipeline, or you're unable to do it for construction issues in the location that I want, thank you for the opportunity, but no thank you. Let's just go ahead and move on from there. So we want to establish those items first because we don't want to sit around and give you some big legal bill and fighting back over terms if we're never going to reach compensation. So there's a way to do this as efficiently as possible to maximize compensation and terms. Okay, back to my case here. This individual sends me then the road right-of-way and easement agreement as well as their gas lease. And they have a very strong gas lease, one of these group leases. So the first thing I'm going to do is to look at, is this road that's being presented, and we get the map too, very important. So is this road going to only be servicing wells that are servicing this client's property, or will wells also be serviced by this road, meaning trucks or water being taken to or from a well that's not going to be servicing, or multiple wells, our client's property? This is very, very tricky, and this is a nice little sneaky thing that landmen will do. That maybe this roadway is going to go to a well site on your neighbor's property, and maybe that well site is going to have wells on that property that's going to be servicing the units that you're participating in. However, maybe that well site is going to have other wells that are going to go into units that you're not participating in. And that's where the company typically runs into a problem. But maybe those well sites or those wells aren't drilled yet or not planned to be drilled anytime soon. Maybe they're not even permitted. Maybe that's done on purpose, where the landman says to you, well, yeah, we have 3 wells permitted and they're for your unit. Well, what about the next 5, 6, 7 wells that you're going to permit? Also, maybe this roadway goes to the neighboring well site, and maybe that well pad or that well site is only going to produce gas from the wells drilled from that site, are only going to produce gas from your property and others in your unit. However, they're going to take a road from that first pad that we're talking about and build another road from there to a second pad on down the line a little bit. And so the roadway that's going across your property to your neighbor's pad, that pad's only going to produce gas from your property and others around you. But they're going to keep going with that roadway and go another, say, a half a mile to another pad. And that pad or wells on that pad aren't going to service your property in any fashion. But since you signed the roadway easement agreement, you're giving a company typically the ability to use your roadway to access any pads and any wells. So even if that pad isn't going to service your property in any fashion, they can use that roadway, which means potentially how much more truck traffic and annoyance, and you're not going to get any extra money for that. And there may be 10 wells drilled off in the next pad that have nothing to do with you, that they're going to be transporting water to and from, and guys going in and out all the time. And then you want to get crazy? How about then if there's even another pad where your roadway goes to your pad, which is a part of you, and your units in production, and then to another pad which you have nothing to do with, and then maybe from there they extend that roadway to another pad that you have nothing to do with, and maybe there's 10 wells drilled off of each of these. Well, that's 20 wells worth of activity where trucks are going to come across your property, and workers and rigs and what have you is going to come across your property to go to service 20 other wells that you have nothing to do with. And they're not going to tell you that. They're not going to tell you that. All right, I'm way over. This is Attorney Doug Clark, listening to All Things Marcellus here. We're here every Sunday from 8 to 9. I'm going to get into the details here when I get right back at this roadway agreement. Please stay tuned. Welcome back to All Things Marcellus with me, Attorney Doug Clark. And again, we're here every Sunday from 8 to 9. And I keep saying this. I am here. Nobody else is with me. I am here. Sometimes people are, but generally I am here myself every Sunday from 8 to 9 a.m. on these stations. And if you want to contact me directly, please do so at 570-307-0702. That's 570-307-0702. Check out the websites at pagasleaseattorney.com, pipelineattorney.com. Great landowner information there. Just check them out. Also, all of the radio shows, we have their archive. They're available on the website, pagasleaseattorney.com. Also, we're putting on YouTube, so you can check them out on YouTube, too. We want to make sure that if you can't catch us every Sunday from 8 to 9, that you can get access other ways. So you can check it out at YouTube, also on iTunes, free in the podcast. Just type in All Things Marcellus. Okay, let me get to this. So, client comes in, says, all right, I got this road right-of-way easement agreement. So first thing I do is check it out. So first off, anytime that an agreement is presented to me consists of about 4 paragraphs, all contained on one page, makes me say, all right, we need to be careful here. What are we doing? The vagueness in agreements are generally a very good thing for the company and very bad for the landowner. So in this particular case, it says the party that goes ahead and identifies the parties, and it says that the landowner is granting the right to open, gravel, repair, maintain, and use an access road with the right to store topsoil and timber at locations situated substantially as illustrated in Exhibit A attached here too. Said roadway is for the purpose of ingress and egress over, on, and through those certain lands, and identifies the property. Okay, maybe that doesn't sound so bad, but what we got here is, the right to very generally build a roadway, maintain it, repair it, and use it. Also have these stacking areas. Very important, but no details, nothing on the size of the roadway. Just say, hey, we can build a roadway. And there is a map, but it's substantially situated. So again, what does that mean, substantially situated? Do you ever want to get into a fight about, well, I thought you couldn't do this or move it here or do that? And they say, well, no, this is substantially the same, so therefore we can do it. And you say, well, that's not substantially the same. And they say, well, yes, it is. And what are you left with? Are you going to file a court action to try to say that that's not substantially similar? So you want to be very careful with these. Okay, so next paragraph. It's understood and agreed that the road, right-of-way, and easement does not and shall not extend generally for use of the public. Okay. Yeah, that sounds really good. To me, that's classic trap language by a company. Oh, well, look, the public can't use this road. Well, no kidding. Why would the public be able to use this roadway? You're granting an easement. I mean, that's just silliness. Now, is it good and okay to have it in there? Yeah, that's fine. But when you look at how few words are on this document and the fact that they're saying that it shall not extend generally for use of the public, they're using that. I can hear the landman. Well, listen, we can only use this and our guys, and it can't be used by the public. No kidding. No kidding. So that's not a big deal. They're not giving you something there. It goes on to say, but is limited for the use of the company, its successors, assigns. Hopefully those S's came out okay. Assigns, meaning they can assign or give somebody else the right to use this roadway. You have to understand assignment. Assignment is killing people across the state. Companies are assigning the gas rights to other companies, royalty rights, portions. What companies are doing too, your gas lease company is assigning the pipeline rights to another company. All these things are happening, and landowners are saying, well, how does this happen? Well, it's because the company can assign the rights. So they're taking this roadway. What can't be used by the general public? Again, no kidding. But who can use it? Well, the company you give the roadway rights to, any of their workers, any of their contractors, and that, look, that makes sense. But then you get to anyone who they assign it to. They can assign to pipeline companies. They can assign to any company. It allows the agreement to be assigned to others. You need to understand that. Do you want them, you sign this agreement with say if you did it with a pipeline company, well, they can give it to a gas company. They can give it to an electric company. They can give it to anybody to allow them to use the roadway, and they'll sell it. They can sell it to these other companies to use the roadway. So it gives them, they can be used by them, their contractors, their employees, their successors, their assigns, who they assign it to. So, and then it goes on, and for persons, firms, and corporations doing work for said company, its successors, and assigns. Again, you got to know what that means. I am Attorney Doug Clark. You're listening to All Things Marcellus. We're here every Sunday from 8 to 9 a.m. with the show, giving landowners the information you need regarding this gas development. Okay, back to the road, right-of-way, and easement agreement. So, next sentence. Where a locked gate exists. Where a locked gate exists. Not, they're going to build one here. Where a locked gate exists. Across the subject access route or roadway. So if there's not a roadway there, you're not going to have a gate there. If there is a roadway there, you may not have a gate there. So this says where a lock gate already exists in the area of the roadway, the company shall be allowed to install a lock in combination with the landowner's lock to facilitate ingress and egress and deter unauthorized access. So remember, this isn't saying that they'll build you a gate at all. It's saying that if this gate already exists in this roadway area, which means you would already have to have a roadway there, because you're not going to just simply have a gate somewhere thinking, oh, maybe someday a roadway will get built here. So they're not telling you they're going to build you a gate. They're just saying if you have a gate, we get to put a lock on it so we can use your gate too. Goes on. Next sentence. This is the next sentence. Grantee agrees to restore the subject access route or roadway as is necessary to correct any damage resulting from the company's use. Well, it gives the inference that we're talking about if there's already an existing roadway there. But when do you restore it? It says, is this when you build the roadway, when you're done using the roadway? How do you do this restoration? This just simply says that the company agrees to restore this access route as is necessary to correct damage. Who's going to determine that? You, them, and are you going to get into a battle? Hey, you damaged this needs to be restored. And they say, no, it's okay. Now where are you at? Are you going to sue them and go into court over this? Next sentence. Said restoration to be as good or better condition than pre-existed the company's use. Once again, when are we talking about this? Are we talking about if you had an existing roadway and they make it better, which is going to be really hard to argue then that they haven't maintained it the right way? So are we talking about doing it after it's built that they're going to reclaim and restore? Or are we talking about 50 years, 100 years, 150 years, 30 years, whatever that time frame is that what we're talking about restoration? It's completely silent to that effect. Next paragraph. The right of way herein granted, so the roadway, is limited to use. Well, geez, okay, limitations. Remember, that's what I'm talking about all the time. Limitations. We love limitations. Company hates limitations. So we say, okay, I like this. I'm digging what I'm reading here right now. The right of way herein granted is limited to use. All right, here we go. Where's this limitation? In connection with companies' ongoing oil and gas exploration and production operations. Whoa, wait a second. Wait. This is a limitation here. Hang on, let's take a step back. This is a limitation. The right-of-way herein granted is limited to use in connection with the company's ongoing oil and gas exploration and production operations. Well, where is that? Are we talking? So we're not talking about what they're doing next door. It's saying oil and gas exploration and production operations. No limitation at all. How do you define that? That's essentially as broad as you can get. So you can use the roadway company as long as it results or is related to any ongoing oil and gas exploration and production operations. Is that in Pennsylvania? Is that in northeastern Pennsylvania? Is that on your property or neighbor's property? Certainly not limited to that scope. This is extremely broad. And it goes on to, okay, so I got to say this whole thing because this is it. This is the end of the agreement, essentially. The right-of-way herein granted is limited to use in connection with their operation, company operation, on oil and gas exploration and production operations, and at such time as said operations shall permanently cease and terminate on your land, on grantor's land. That's great. Okay, so now we're talking. They're going to say that this is going to terminate also at the time that their operations permanently cease and terminate on the landowner's property. There's some more. And other lands in the vicinity for which the company uses said right-of-way. Then it goes on to say, then, and in that event, the right-of-way granted shall cease and determined to be of no further effect. All right. I apologize because I know that's a long sentence. But this is crazy. We want to say, hey, company, if we're going to agree to a roadway, you're going to access this area. When this area is done producing gas, you no longer can use the roadway. Pretty darn simple. Let's just all get on the same page. Why does the company present this to you? Because they only want to access this pad next door? Because this is all they need? Well, why do they present it to you? They present it to you because they want it. And here's what they want. The right-of-way herein granted. So the roadway is limited to use in connection with the gas company's ongoing oil and gas exploration and production operations. No such limitation as to where these could be occurring. And at such time as said operations shall permanently cease. So as long as they're going at all, even if they're paused 50, 100 years, some wells are shut in, they're restarted, that hasn't permanently ceased, so this is still alive. So as said operations shall permanently cease and terminate on your property. That sounds good, but it goes on to say, and other lands in the vicinity of your property for which the gas company is using the right-of-way. So remember how I said earlier, and this wasn't even a setup, it's just walking right into this. How I said earlier, your roadway may go to a pad that is servicing your property in part, but then that roadway may continue, so it's one long roadway to other pads in the region. I see this all the time. There could be an entry point from a township or a state road across your property. You agree to a roadway because you say, okay, that's going to a well site where I'm going to get royalties. But then, that roadway stops there at the first well site, but it also continues on to another well site and maybe even another and possibly even more. What that means is now you're exposed to a lot more potential truck traffic to service all of these other pads. And remember that if the first pad in this chain of pads that this roadway is going to access, in my example, that first pad, it may have wells, and many times it does. There may be wells off of that pad which you're not going to benefit from. And when you're not going to benefit from those wells, in most cases, you don't have to agree to that roadway. That's where we have to look at your pipeline right-of-way agreement. Okay, I'm up against it again. I'll be right back. I'm going to go through the end of this, and I'm going to explain some more what's going on and kind of wrap this up. But hopefully you can see here, this is way too expansive, and I'm going to really bring it home here. I hope here in this last section. I am Attorney Doug Clark. You're listening to All Things Marcellus, and we'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And again, we're here every Sunday. I am here every Sunday from 8 to 9 a.m. And you can always contact me directly at 570-307-0702. Check out the websites at pagasleaseattorney.com, pipelineattorney.com. All right, jumping right into it because I got a short segment here. All right, I'm talking about this roadway easement agreement. I went through the terms of the agreement. Essentially, there's nothing else to this agreement except some just boilerplate language here at the end. So this is a wide open, vague agreement with no termination date, no size limitations, none of those things. So we go back to this gas lease. Now, remember, first thing you should do is call someone for assistance to make sure that you're understanding what your options are. But do you even have to sign this roadway agreement? Do you even have to sign a pipeline agreement? That's a critical and wonderful question to ask. Then when you hear it, don't necessarily believe what you're told by the company representative, because often they'll say, well, we have the ability to do this under the gas lease. Well, very often that's simply not true, or that it's true in part but false in part, meaning that maybe right now with the wells that you have planned on this neighboring pad, you can put a roadway in because it's only going to service wells that I'm going to benefit from. However, in the future, you're going to company, or you may, but a lot of times they know, they're going to drill other wells which aren't going to benefit you. So they're going to use this roadway that will benefit you, which is normally allowed under a lease, but they're also going to use it in a way that's not going to benefit you. But once you sign this agreement, they can use it for whatever they want within that agreement term. So it's much broader. So we go back, and here's the other thing. How much is this person offered? I'll just put it this way. Less than $1,000. Less than $1,000. It's amazing to me that the company and that these guys have, and I know why they have the ability to go out there, is because people sign these things. I don't even understand how they have the stomach to go out and present these things to people, because they're terrible. I don't know how they sleep at night. I couldn't do it. They all have jobs to do. That's fine. And I guess, the answer is, well, landowner, you should go get assistance. You're signing it. You had the ability to get help, but then they try to deter you from doing that. You have to understand it is very calculated from the company's perspective. So going to the gas lease, remember, so you say, okay, can the company do this? And is there any restrictions? Well, this person has a very strong gas lease. And just a couple of the highlights from the gas lease, it's only to allow one road to access the well location is going to service this property. Travel is confined to this area. It also talks about the types of materials that need to be used in making this roadway. It talks about that it must provide a smooth, rut-free, all-weather surface for use by automobiles. And then it goes on, and there's a lot of other things here too, but this is a critical part. During the construction phase, the graded width, what they can clear out here, shall not exceed 40 feet, and the width shall revert to a 20-foot travel corridor once construction is complete. That's very, very important. I have had clients with roadways where the clearing area is in excess of 100 feet. I've seen it requested or put on documents of 130 and 130 plus feet to clear for a roadway. It sounds insane, but I promise you I've seen it. So your lease says you can't clear a path more than 40 feet, and the actual roadway itself can't be wider than 20 feet. Well, remember what I just read to you, the roadway agreement in the last segment? There was no size restrictions whatsoever. So you're signing this agreement thinking, oh, it's going to be some small roadway, and I've seen people do this, and all of a sudden the permitting plans come in and they're clearing 100 feet or more. Well, your lease says only 40. You're talking about a guy being offered less than $1,000. Well, if this roadway was even going to be allowed under the lease, you are probably better off saying, go ahead and install the roadway under my lease, because at least then it can't be more than 20 feet wide when you're done, and you can't clear more than 40 feet during construction, a total of 40 feet. So you know what? I don't want to give you this unlimited size. Well, you're going to find the company's probably going to say, well, we can't do that. Well, then, you know what? Now you're asking me to modify or change my lease, which means either I can say no because I don't want this impact to go through my property. Roadways are bad. I don't like roadways. If I was a landowner out there, I'd take a pipeline any day before a roadway. So we want to make sure if you're getting a roadway that you're maximizing that situation, or if you can say no and you want to say no, that you're saying no. These roadways are there. They're going to stay there as long as that pad exists. And if it's going to other pads, as long as they exist. So, 50 plus years is very reasonable as an anticipation or expectation here. So again, this lease has these limitations. You know what else this lease has? Double stumpage. You're going to probably, if this person went under the lease, there's a good chance they may make more money under the lease terms than they're being offered with the actual roadway easement agreement. And the lease provides these restrictions on size. They give you all kinds of landowner input. And so, don't be afraid to say, you know what, company, I'm not afraid of your threat to go under the lease because I have a good lease. And if you want to operate under my lease, go ahead. You have to pay me double stumpage. You have to pay me damages. We have to work on location of these issues. There's a lot of other things in my lease that you have to follow. So you need to understand that lease agreement. So now, here we are. Landowner says, well, you know what? I didn't realize these things. The company landman never told me that. They just told me how I was going to get rich because they were going to put this roadway and I was going to have all these benefits. And the company's guys do this. They buddy up to you and they say, well, this is what we're doing and you're going to get all this money and this and this and that and paint this rosy picture. Well, they don't tell you. And remember I said before, there's going to be a timber stacking area, a soil stacking area where your lease says 20-foot right-of-way, permanent, and you can clear a total of 40 feet when you're building this roadway. Well, that's not going to allow for these other stacking areas, and that's not your problem. That's not your problem because we're circling back. Remember how I said at the beginning, If the company has the ability, they're going to say, well, your lease allows us to do this. Well, when they don't have the ability, you say, well, company, respectfully, I have these lease terms and I negotiated them for a specific reason that I didn't want this problem in the future. So I'm going to either say no to this proposal or I'll work with you, but your offer of less than $1,000 is never going to work for me. And you might be able to get 15, 25, 50, 100, who knows? But you say, look, here's what I want. Here's the size I want, location, all of these issues. You can address and negotiate those. And if you don't like them, then you don't have to do it. And you have to understand your circumstance. So this particular individual, in my opinion, is going to make out very well by one of two ways. Either he won't have a roadway because he doesn't want it, and the company can't meet the terms that he'll agree to, or he will ultimately agree to a roadway, but that roadway is going to have substantially more terms that's going to define where this roadway can go, what it can be used for, and it's also going to have a lot more compensation. It's going to have more in reclamation, and it's going to be a total different ending point than what was presented. So by getting assistance, by getting help, he will, I am confident, increase the compensation by at least 20 times and possibly much higher, and also get much better terms. Please do not sign or agree to anything. Get some assistance. I am Attorney Doug Clark. You're listening to All Things Marcellus. Have a great week, everyone.